Hello and welcome to the prelims practice session for the upcoming preliminary examination. Now this video is in continuation with our series where we have been discussing practice questions related to the static part of the syllabus. And this video is related to the second week of polity section. So in this line, I hope you have been revising the polity section from the NCERT and standard reference books. So after this, let us look at the topics that we are going to discuss in this video. Now we all know that the prelims examination is all about a balance between the current affairs and the core section. So this video is related to the polity part of our syllabus. Now already in the previous video we have discussed questions from these important themes of the Indian polity. And we have discussed questions related to the salient features of the Indian Constitution, the fundamental rights, the right to principles and fundamental duties. Also we have discussed questions from the amendment of the Constitution, the systems of government and the center-state relation. Now in this video, we'll be discussing the questions from another important themes of our syllabus related to polity. And in this, we'll be discussing questions from the emergency provisions, the President and Vice President, Prime Minister and the Council of Ministers. And lastly, we'll be discussing questions from the Parliament, budget and the legislative process. And if you look at the previous year papers, you will find that a lot of questions have been asked from this important chapter of polity, that is the Parliament. So we have discussed almost 4 to 5 questions related to the Parliament, budget and the legislative process. So with this, let us start our discussion of this video.
Now before taking up the practice questions, let us look at the way in which UPSC has asked questions in the previous years from some important topics like the President and the Vice President, the Prime Minister and the Council of Ministers. So if you look at these questions, they were asked in the year 2018. Again, there was a question in the year 2018 and this next question was asked in the year 2014. Now, questions related to the President of India have been asked in different contexts. For example, this question that was asked in 2018 was related to the President's rule. Second question that was asked was related to the procedure of election of the President of India. And then the next question that was asked in 2014 was related to the constitutional position of the President of India. Now the first question that was asked in 2018 reads, if the President of India exercises his power as provided under the Article 356, then what is the likely consequence of such exercise of power? So basically this requires us to identify the consequence of the President's rule. Now if you go through the emergency chapter, you will find that there are 3 types of emergencies. First is the national emergency, the second one is the President's rule, and then there is financial emergency. So in all these cases, you should be aware about the consequence of proclamation of these emergencies. And they can be a very important aspect for us from the preliminary examination point of view. Now for solving this kind of questions, our focus should be on eliminating the wrong statements first. So if you look at the first option, that is the assembly of the state is automatically dissolved. So this is not a consequence of the imposition of President's rule because the assembly does not automatically get dissolved. Now this is because once the President rule is declared, the President can either suspend or dissolve the state legislative assembly, which means that it does not automatically get dissolved. Further, if you look at the third option, that is the C option, it talks about the suspension of Article 19, which is a fundamental right. However, in the case of President's rule, there is no restriction on the fundamental rights of the citizen, and hence you can eliminate this C option. And if you look at the last option, that is D, the President can make laws relating to that state. Now this statement is also incorrect because the President can declare that the powers of the state legislature are to be exercised by the Parliament, and he cannot himself assume this thing of creating the laws for that state. So in this case, the correct answer that comes out is B, that is the powers of the legislature of that state shall be exercisable by or under the authority of Parliament. So while solving such questions where there are 4 statements and 4 options, you should always try to eliminate the wrong statements to arrive at the correct answer. And this should be your approach while solving such kind of questions. Now after this, if you look at this second question, it reads that with reference to the election of President of India, consider the following statements. And first is that the value of vote of each MLA varies from state to state. And the second statement is that the value of vote of MPs of the Lok Sabha is more than the value of the vote of MPs of the Rajya Sabha. Now, regarding the procedure of election of the President of India, the Constitution provides that there shall be uniformity in the scale of representation of different states, as well as there should be parity between the states as a whole and the union at the election of the President. And accordingly, the formula for the calculation of value of the vote of an MLA and the value of the vote of a member of parliament have been provided in the Constitution. Now, regarding the formula which is used for the calculation of value of vote of an MLA, you will find that there is mention of the total population of the state. Now, this total population varies from state to state, and accordingly, the value of vote of each MLA from state to state is not equal and it varies, and hence the first statement here is correct. Now, regarding the value of vote of a member of parliament, it is arrived at by dividing the total value of votes of all the MLAs of all the states by the total number of elected members of the parliament. And hence, there is a parity between the value of vote of both the Lok Sabha as well as value of the vote of members of Rajya Sabha. And hence, the value of vote of member of parliaments of Lok Sabha is not more than that of the value of vote of MPs of Rajya Sabha. And hence this statement here is incorrect. So the correct answer that comes out in this question is A, that is 1 only. And if you look at this third question that was asked in the year 2014, it is related to the executive power of the President of India. So the first statement, that is, the President shall make the rules for more convenient transaction of the business of the Government of India and for the allocation among the ministers of the said business, is a correct statement. And this is one of the executive powers of the President of India. However, the second statement that is given here is incorrect because all the executive actions of the Government of India shall be expressed to be taken in the name of President and not the Prime Minister of India. And this is because all the executive actions of the Government of India are formally taken in the name of the President. And this is because he is the head of the state. And hence the correct answer that comes out here is A, that is 1 only. Again, these three questions were asked in the previous years, in the years 2015, 2014 and 2013. Now, this question that was asked in the year 2015 was again related to the constitutional position of the President of India, and it was related to the executive powers of the President. So if you look at this first statement, it reads that the executive power of the Union of India is vested in the Prime Minister, and which is the incorrect statement. And here you should notice that this particular statement was also asked in the previous year, in the year 2014. So this highlights that solving previous year questions can be important for us for the upcoming preliminary examinations. And if you look at this second statement, the Prime Minister is not the ex officio chairman of the Civil Services Board, and it is the Cabinet Secretary. And hence this statement was also incorrect. So the correct answer here was D, that is neither 1 nor 2. Further, if you look at this question that was asked in the year 2014, it was related to the functions of the Cabinet Secretariat. Now, in this, if you knew that the allocation of financial resources to the ministries is not a function of the Cabinet Secretariat, you can easily eliminate the options B and D. And by this, you can zero down the options to 2, that is A and C. And if you know about the functions of the Cabinet Secretariat, it is the preparation of agenda for the Cabinet meetings, and also it provides secretarial assistance to the Cabinet committees. And hence the correct answer here was C, that is 1 and 2 only. Further, if you look at this question that was asked in the year 2013, it reads that in the context of India, which of the following principles is or are implied institutionally in the parliamentary government? Now, this is related to the functions of the Council of Ministers. And in solving this question that was asked in 2013, again you should identify the incorrect statement in all these three statements. So if you read this third statement, that is Cabinet is headed by the head of state, it is an incorrect statement because the Cabinet is headed by the Prime Minister of India. And by this you can easily eliminate the options B, C and D. And with this, the correct answer that comes out is A, that is 1 and 2 only. Now, these questions highlight that UPSC requires conceptual clarity about important themes in the Indian polity. And again, the approach for solving the questions should be correct. That is, you should always look for incorrect statements based on your conceptual knowledge. And by this, you can easily eliminate at least 2 options. And in some cases, you can easily eliminate all the 3 wrong options. Now, after this, let us take up the practice questions that we have created based on these previous year questions related to the topics of President and Vice President and also the Prime Minister and the Council of Ministers. Now, based on the previous year questions, we have formed these two questions related to the President of India. And in this, the first question reads that which of the following statements is or are correct about the President of India? First is that the pardoning power of the President of India is an executive power. And the second statement is that the 42nd Constitutional Amendment Act authorized the President requiring the Council of Ministers to reconsider the advice tendered to him by such council. So in this, the first statement is related to the pardoning power of the President and the second is related to the constitutional position of the President. Now, as far as the first statement is concerned, you should note that the pardoning power of the President has been provided under the Article 72 of the Indian Constitution. Now, this pardoning power of the President is independent of the judiciary and is an executive power. And this is because the President, while exercising this power, does not sit as a court of appeal and hence it is not a judicial power and it is an executive power. Now, this aspect can also be ascertained from the logic behind conferring of such power on the President. So, it was to keep the door open for correcting any judicial errors in the operation of law and also to afford relief from a sentence which the President regards as unduly harsh. And in this regard, the observations of the Supreme Court are also important. And the Supreme Court has examined that the President can examine the evidence afresh and take a view different from the view taken by the court. However, the petitioner for mercy has no right to an oral hearing by the President. And further, the Supreme Court in its guidelines has clearly clarified that the pardoning power of the President is to be exercised based on the advice of the Union Cabinet, which means that the President has to act on the advice of the Union Cabinet, which represents the Union Executive. And hence, this pardoning power of the President of India is an executive power and is not a judicial power. So, this first statement is correct. Further, regarding the second statement, which is related to the constitutional position of the Indian President, the Article 74 reads that there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the Prime Minister, who shall in exercise of his functions act in accordance with such advice. Now, in this line, the 42nd Constitutional Amendment Act of 1976 made the President bound by the advice of the Council of Ministers headed by the Prime Minister. However, the 44th Constitutional Amendment Act of 1978 authorized the President to require the Council of Ministers to reconsider such advice either generally or otherwise. So, this means that this power for the reconsideration of the advice tendered by the Council of Ministers to the President was not provided by the 42nd Constitutional Amendment Act and it was provided by the 44th Constitutional Amendment Act. And hence the correct answer here is A, that is one only. Now, the second question related to the President of India is regarding the ordinance making power of the President. And the question reads, which of the statements given below is or are correct about the ordinance making power of the President? And the question reads, which of the statements given below is or are correct about the ordinance making powers of the President? First is that the President can promulgate ordinance only when the Lok Sabha is not in session. Second statement reads that the President's satisfaction with regard to the promulgation of ordinance cannot be subjected to judicial review. Now, this ordinance making power of the President has been provided under the Article 123 of the Indian Constitution. And this article of the Indian Constitution empowers the President to promulgate ordinance during the recess of the Parliament. And this power has been provided to the President of India to deal with unforeseen or urgent matters. Now, all such ordinances can be promulgated only when both the houses of the Parliament are not in session or when either of the two houses of the Parliament is not in session. So, this means that an ordinance can also be issued when only one house is in session, because a law can be passed by both the houses and not by one house alone. And if you look at this statement that President can promulgate ordinance only when the Lok Sabha is not in session stands incorrect. And this is because the President can promulgate ordinance when both the houses are not in session or either one of the houses is not in session. So this is not the only condition for the promulgation of the ordinance, and hence this word should have been carefully watched in this statement that the President can promulgate ordinance only when the Lok Sabha is not in session, and hence this statement is incorrect here. Now, regarding the second statement, you should note that the president can make an ordinance only when he is satisfied that the circumstances exist that render it necessary for him to take immediate action. However, in the Cooper's case of 1970, the Supreme Court has held that the president's satisfaction can be questioned in a court on the ground of malafide. Now, in this regard, the 38th Constitutional Amendment Act of 1975 made the president's satisfaction final and conclusive and beyond the judicial review. However, this provision was deleted by the 44th Constitutional Amendment Act of 1978, and hence the president's satisfaction with regard to the promulgation of ordinance can be subjected to judicial review, and hence this statement given in the question is incorrect. So again, the correct answer here is D, that is neither the statement 1 nor the statement 2 is correct. Now, the third and the fourth questions are related to the Prime Minister of India and the Council of Ministers and the various provisions related to the appointment and selection of the PM, as well as regarding the Cabinet and the Council of Ministers. So in this regard, the third practice question reads that consider the following statements. The first is that the Constitution clearly specifies the procedure for the selection and appointment of the Prime Minister of India. And the second statement is that the Union Ministers hold the office during the pleasure of the President. Now, the appointment of the Prime Minister has been dealt in the Article 75 of the Indian Constitution. And this article reads that the Prime Minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the Prime Minister. So this article reads only that the Prime Minister shall be appointed by the President, and it does not clearly specify the procedure for the selection and the appointment of the Prime Minister of India. And hence the first statement here is incorrect. Now, as the Constitution does not clearly specify the procedure for the selection and appointment of the Prime Minister of India, he or she relies on the convention of the parliamentary system of the government. And in this case, the President has to appoint the leader of the majority party in the Lok Sabha as the Prime Minister. Further, when there is lack of clear majority in the Lok Sabha, then the President exercises his personal discretion in the selection and the appointment of the Prime Minister. And this discretion was first exercised by the President for the first time in the year 1979. So this can also be an important fact for us from the preliminary examination point of view. And as far as the second statement is concerned, the Article 75 reads that the ministers in the Union shall be appointed by the President on the advice of the Prime Minister. And these ministers shall hold the office during the pleasure of the President. And hence, this statement here is correct. So the correct answer is B, that is 2 only. Now, regarding the second statement, you should also understand that the Article 75 contains the principle of individual responsibility, and it states that the ministers hold office during the pleasure of the President, and which means that the President can remove a minister even at a time when the Council of Ministers enjoys the confidence of the Lok Sabha. However, the President can remove a minister only on the advice of the Prime Minister of India, and by exercising this power, the Prime Minister can ensure the realization of the rule of collective responsibility of the Council of Ministers. Now, after this question, you should understand that 3 important articles of the Indian Constitution deal with the parliamentary system of the government. And these articles are the Article 53, the Article 74 and the Article 75. And these provide for the relation between the Prime Minister and the Council of Ministers and various other important provisions of the Council of the Ministers. And these are the articles which lay at the base of the parliamentary system which is functional in India. And they are extremely important for us from the preliminary examination point of view. So after this, let's take up this fourth practice question now. Now this fourth question reads that consider the following statements. The first statement is that the term cabinet has not been mentioned in the Constitution of India. Second is that the Council of Ministers ceased to hold the office after the dissolution of Lok Sabha. And the third statement is that a minister can only be removed from the office if a no confidence motion is passed in the Lok Sabha. Which of the statements given above are correct? Now regarding the first statement, you should know that the term Council of Ministers has been mentioned in the Articles 74 and the 75 of the Constitution. And they were provided in the original Constitution itself. However, this term cabinet was nowhere mentioned in the original copy of the Constitution. And this term cabinet was inserted under the Article 352 of the Constitution in 1978 by the 44th Constitutional Amendment Act. Now, the Article 352 originally deals with the proclamation of national emergency, and it provides that the President can declare a national emergency when the security of India or a part of it is threatened by a war or external aggression or armed rebellion. Now, regarding this proclamation of emergency under the Article 352, the 44th Constitutional Amendment Act provided for a safeguard, and it provided that the President can proclaim a national emergency only after receiving a written recommendation from the Cabinet. And this means that the emergency can be declared only on the concurrence of Cabinet and not merely on the advice of the Prime Minister. And in the year 1975, the Prime Minister of India, Indira Gandhi, advised the President to proclaim emergency without consulting the Cabinet of that government. And that is why this safeguard was inserted by the 44th Constitutional Amendment. And hence the term cabinet was for the first time inserted into the Indian Constitution by the 44th Constitutional Amendment Act in the year 1978. And this first statement is incorrect because the term cabinet has now found a mention into the Indian Constitution based on the 44th Constitutional Amendment Act. Now, regarding the second statement, the Constitution under the Article 53 provides that the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. And further, the Article 74 provides that there shall be a council of ministers with the Prime Minister at the head to aid and advise the President. However, originally the Constitution did not provide that such aid and advice will be binding on the President. And it was only after the 42nd and the 44th Constitutional Amendment Acts that the advice tendered by the Council of Ministers was made binding on the President of India. And in the year 1971, the Supreme Court held that even after the dissolution of the Lok Sabha, the Council of Ministers does not cease to hold the office. So in short, the Article 74 is mandatory and therefore the President cannot exercise the executive power without the aid and advice of the Council of the Ministers. So even after the dissolution of the Lok Sabha, the Council of Ministers does not cease to hold the office. And hence this second statement is also incorrect. And further, regarding this third statement, the President can remove a minister even at a time when the Council of Ministers enjoys the confidence of the Lok Sabha. And there is no need of no confidence motion for removal of a minister in the government. And the President removes a minister only on the advice of the Prime Minister of India. And this provision has been provided under the Article 75 of the Indian Constitution. And by exercising this power, the Prime Minister ensures the realization of the rule of collective responsibility. So again, this third statement is also incorrect. And hence the correct answer that comes out is D, that is none of the above statements are correct. And after this, let's take up the fifth practice question. Now this fifth practice question has been created based on the chapter of emergency. And in this, if you look at the question that was asked in the year 2017, it was related to the President's rule in a state. And we have already discussed a question related to President's rule which was asked in the year 2015 at the beginning. Now this question reads, which of the following are not necessarily the consequences of the proclamation of President's rule in a state? First is the dissolution of the State Legislative Assembly. Second is the removal of the Council of Ministers in the state. And third is the dissolution of local bodies. Now again, it is related to the consequences of the President's rule in a state. And we note that when the President's rule is imposed in a state, the President dismisses the State Council of Ministers headed by the Chief Minister. So a necessary consequence of the proclamation of President's rule in a state is that removal of Council of Ministers takes place immediately. However, regarding the first and third statement, these are not necessarily the consequences of the proclamation of President's rule in a state. So regarding this first statement, we note that after the proclamation of President's rule in a state, the President either suspends or dissolves the State Legislative Assembly. However, this is not a necessary consequence of the proclamation of President's rule in a state. And hence, this statement here is correct in the context of the question. And further, regarding the third statement, which is related to the dissolution of the local bodies, You should note that the proclamation of president's rule in a state does not have any impact on the functioning of the local bodies. And hence the third statement is also correct in the context of the question, because this is also not necessarily a consequence of the proclamation of president's rule in a state. And hence the correct answer here is 1 and 3 only, that is the B option. Now, while solving such questions, you should always be careful about the language of the formation of that question. And if you look at this question, it requires us to identify which of the following are not necessarily the consequences of the president's rule in a state. And hence, this term, that not necessary consequence, becomes important while solving this question. So after this, let us take up this practice question related to the emergency provisions. So it reads that which of the following statements is or are correct about the grounds for the imposition of president's rule. So in this regard, the first statement reads that the president can issue a proclamation only on the basis of governor's report. Second statement reads that the Article 355 imposes a duty on the center to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. Now, regarding the president's rule, you should note that the Article 355, Article 356 and Article 365 of the Indian Constitution are extremely important. And this Article 355 imposes a duty on the center to ensure that the government of every state is carried on in accordance with the provisions of the constitutions. Hence, the second statement here is correct. Further, the Article 356 empowers the president to issue a proclamation if he is satisfied that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the constitution. And in this case, the president can either act on the report of the governor of the state, or he can also act otherwise too, that is, even without the governor's report. And hence, this first statement is incorrect, because it is not necessary that the president issue a proclamation only on the basis of governor's report. And hence, the correct answer here is B, that is 2 only. And further, the Article 365 says that whenever a state fails to comply with or to give effect to any directions from the center, it will be lawful for the president to hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the constitutions. So regarding this president's rule, all these articles, that is the Article 355, 356 and 365, provide for the grounds of imposition of president's rule in a state. So again, it needs to be reiterated that you should always learn about the grounds for the imposition of national emergency, the president's rule and the financial emergency. And also you should learn about the consequences of the proclamation of these three kinds of emergencies that have been provided in the Constitution of India. With this, let's take up the next question now. Now, the next 5 questions are based on one of the important topics in the Indian polity, that is Parliament, budget and the legislative process. And before taking up these practice questions, let us look at the way in which UPSC has asked questions from this section in the previous year's preliminary examinations. Now, from this section of the Indian polity, that is Parliament, budget and the legislative process, maximum questions have been asked in the preliminary examinations. In the year 2018, there were 3 questions asked from this topic of Parliament, budget and the legislative process. Now, if you look at this first question, 3 statements were given in this question. However, to solve this question, you only had to recognize the third statement, which is incorrect here. And it reads that in the Lok Sabha, if a party does not have a minimum of 75 members, its leader cannot be recognized as the leader of opposition. Now, this statement given here was incorrect, because the condition for getting the position of leader of opposition is only that a party gets 10% of the total membership of the Lok Sabha. Now, we know that at present the total membership of the Lok Sabha is 545 members. So the 10% of that membership is about 55 seats in Lok Sabha. So in order to get the recognition of leader of opposition, a party should have minimum of 55 members in the Lok Sabha. And hence this third statement is incorrect here. And by this you can easily eliminate the options A, C and D. So the correct answer that comes out is B, that is 2 only. Again, this question that was asked in 2018 is related to the parliamentary committees. And it requires us to identify that which of the following parliamentary committees scrutinizes and reports to the House whether the powers to make regulations, rules, sub-rules and bylaws conferred by the Constitution or delegated by the Parliament are being properly exercised by the executive. Now, this is related to another important aspect of the legislation section, And in this, you should note that it is related to the delegated legislation. So in this case, again, the correct answer that comes out is it is related to the Committee on Subordinate Legislation. And again, the third question that was asked in 2018 from this chapter is related to the money bill. However, this question should be read carefully and it requires us to identify which of the following statements is not correct. Now, if you go through the details of money bill, you will find that a money bill is not concerned with the appropriation of money out of the contingency fund of India. And hence, the C is the correct statement here because it is the only incorrect statement given in the 4 options. Further, if you look at the year 2017, there were 2 questions from this chapter. The first question is related to the private members' bill, and the first statement in this question reads, a private members' bill is a bill presented by a member of the parliament who is not elected but only nominated by the President of India, which is an incorrect statement. This is because a private member's bill can also be presented by an elected private member of the parliament. Further, the second statement is that recently a private member's bill has been passed in the Parliament of India for the first time in its history, and this is also incorrect statement because more than 14 bills have been passed by the Parliament which have been presented by the private members, and hence the correct answer here was D, that is neither 1 nor 2. Now again, the second question that was asked in 2017 was related to the Parliament of India exercising the control over the functions of the Council of the Ministers. And in this case, all the 3, that is, it exercises the control over the functions of the Council of Ministers through the adjournment motion, the question R and the supplementary questions. And hence the correct answer here was D, that is 1, 2 and 3. Further, if you look at this question that was asked in 2016, it was related to the dissolution of the Lok Sabha and its impact on the pending bills. So the first statement reads, a bill pending in the Lok Sabha lapses on its prorogation, which is an incorrect statement because a bill pending in the Lok Sabha lapses only when the House is dissolved and not prorogued. And the second statement that a bill pending in the Rajya Sabha which has not been passed by the Lok Sabha shall not lapse on dissolution of the Lok Sabha is a correct statement. So the correct answer here was B, that is 2 only. Further, in the year 2015, there were 2 questions from this section, and in the year 2014, again, there were 2 questions from this section. So if you look at this question that was asked in the year 2015, it reads, when a bill is referred to a joint sitting of both the houses of parliament, it has to be passed by. So it has to be passed by a simple majority of the members present and voting. And there is no special kind of majority that is required for the passage of a bill in a joint sitting. Further, if you look at this question that was asked in 2015, it was related to the process of budget. And in this question, the first statement was correct because the Department of Economic Affairs is responsible for the preparation of union budget, and hence this statement was incorrect. Again, the third statement that all the disbursements made from the public account also need the authorization from the Parliament of India is also incorrect. Hence, the correct answer that comes out is 2. That is, no amount can be withdrawn from the Consolidated Fund of India without the authorization from the Parliament of India. And hence, the correct answer here was C, that is 2 only. The question that was asked in 2014 was related to the no confidence motion, and in this the first statement was correct because there is no mention of a no confidence motion in the Constitution of India, and this is a convention of the parliamentary system. The second statement that a motion of no confidence can be introduced in the Lok Sabha only is also correct. This is because the Council of Ministers are responsible to the Lok Sabha only, and this no confidence motion is passed in the Lok Sabha to defeat the confidence of the House on the Council of the Ministers. And hence, the correct answer here was C, both 1 and 2. And the next question that was asked in 2014 was related to the parliamentary committees, and the question reads, which one of the following is the largest committee of the parliament? And in this, the correct answer was the Committee on Estimates because it has 30 members, while the Committee on Public Account and the Committee on Public Undertakings has 22 members each. So by this discussion, you should have understood that the questions have been asked based on this important section of the Indian polity. And various questions have been asked related to the budget. For example, this question, and also a question was asked related to the money bill. Then there have been questions related to the legislative process. For example, the joint sitting and the private members bill. Then again, there have been various questions related to the parliamentary committees and also related to the parliamentary control over the Council of Ministers. For example, questions have been asked related to the no confidence motion and also related to the adjournment motion, etc. So after this, let us look at the practice questions related to this section of the Indian polity. Now the sixth practice question is related to the organization of the Parliament of India, and it reads that the Indian Parliament consists of which of the following? First is the President of India, second is the Lok Sabha, and third is the Rajya Sabha. Now the organization of the Indian Parliament has been done based on the form of government which we have adopted in the Indian Constitution. And as we all know that India has gone for the parliamentary form of government. And this form of government emphasizes on the interdependence between the legislative and the executive organs. However, as opposed to the parliamentary form of government, in the presidential system, there is complete separation between the legislative and the executive organs. And in this line, India has relied on the British parliamentary model, where the Parliament of Britain consists of the Crown, that is either the King or the Queen, the House of the Lords, which is the upper house, and the House of the Commons, which is the lower house. And thus, in India's case, the Indian Parliament consists of three parts, and that is the President, the Lok Sabha, and the Rajya Sabha. However, it should be noted that the President of India is not a member of either of the houses of the Parliament, and he does not sit in the Parliament to attend its meeting. However, still he is an integral part of the Parliament. And this is because of the parliamentary form of government which we have borrowed from the Britain. Now, in contrast to this, the American president is not an integral part of the legislature. And in case of United States of America, the legislature, which is known as the Congress, consists of the Senate, which is the upper house, and the House of Representatives, that is the lower house. And in that case, the president is not an integral part of the legislature of the United States of America or the Congress of the USA. And thus the correct answer that comes out here is D, that is 1, 2 and 3. Now the seventh question is related to the budget of the Government of India, and it reads, consider the following statements about the budget of Government of India. The first statement is that the demands for excess grant can be submitted to the Lok Sabha only if it has been approved by the Estimates Committee of the Lok Sabha. Second is that all the expenditures from the Consolidated Fund of India have to be voted by the Parliament. So regarding the budget, we already know that it is a statement of the estimated receipts and expenditure of the Government of India in a financial year. Now, besides the budget, the Constitution also provides for various grants that are made by the Parliament under the extraordinary or special circumstances. And these grants are known as the supplementary grants, the additional grants, excess grants, vote of credit or exceptional grant, etc. So in this case, regarding the excess grant, you should note that it is granted when the money has been spent on any service during a financial year in excess of the amount granted for that service in the budget for that year. Now, an important aspect of this excess grant is that it is voted by the Lok Sabha after the financial year. However, a condition has been imposed on this grant that before the demand for excess grants are submitted to the Lok Sabha for voting, they must be approved by the Public Accounts Committee of the Parliament and not by the Estimates Committee of the Lok Sabha. And hence, this statement here becomes incorrect. Now, we know that the excess grant is granted when the money has already been spent on any service during a financial year. And the parliamentary committee which examines the public expenditure is the Public Accounts Committee and not the Estimates Committee. And this is because the Estimates Committee's function is to examine the estimates which are included in the budget, and it suggests the economies in the public expenditure that will be made by the government. And hence you could have easily eliminated this statement if you knew about the concept of excess grant and also about the functions of the Estimates Committee and the Public Accounts Committee. And regarding the second statement, you should note that the budget consists of two types of expenditures from the Consolidated Funds of India. The first is the expenditure charged upon the Consolidated Fund of India, and second is the expenditure made from the Consolidated Fund of India. And in this case, the charged expenditure is non-votable by the Parliament, and thus such kind of expenditure can only be discussed in the Parliament. However, it cannot be voted upon. However, regarding the expenditures which are made from the Consolidated Fund of India have to be voted upon by the Parliament. And hence this statement also becomes incorrect because the charged expenditures are not voted by the Parliament. And these charged expenditures include the emoluments and the allowances of the President of India, the salaries and allowances of the chairman and the deputy chairman of the Rajya Sabha, salaries, allowances and pensions of the judges of the Supreme Court, etc. And hence the correct answer that comes out in this question is D, that is neither the statement 1 nor the statement 2 are correct. With this, let's take up the next question now. Now this 8th question is related to the parliamentary control over the Council of Ministers. And the question reads, which of the following statements is or are correct about the parliamentary control over the Council of Ministers? The first statement is that the 0R has been provided in the rules of procedure of the Lok Sabha for the members to raise matters related to the functioning of Government of India. And the second statement is that the adjournment motion can be introduced only in the Lok Sabha. Now, normally during the parliamentary proceedings, the members ask questions to the ministers regarding the government policies during the question hour. However, an informal device is also available to the members of the parliament to raise the matters of the Government of India. And this informal device is known as the 0R, which starts immediately after the question hour. Now, this device of the parliamentary proceeding is an Indian innovation in the field of parliamentary procedures, and it has come into existence since the 1962 only. Now, an important fact regarding the 0R is that unlike the question hour, which is provided for in the rules of procedure of the Lok Sabha, this 0R is not mentioned in the rules of procedures of the Lok Sabha, and hence this first statement becomes incorrect here. And regarding the adjournment motion, you should note that it is introduced in the parliament to draw attention of the house to a definite matter of urgent public importance. And this adjournment motion interrupts the normal business of the house, and that is why it is regarded as an extraordinary device. Now further, this adjournment motion involves an element of censure against the government, and hence the Rajya Sabha is not permitted to make the use of this device. And hence this second statement here is correct, that is the adjournment motion can only be introduced in the Lok Sabha. So the correct answer that comes out is B, that is 2 only. Now the next question reads that which of the following statements is or are correct about the Estimates Committee of the Parliament? First is that it consists of members from the ruling party only. Second is that the demand for grants can only be voted upon after the budget estimates have been examined by this committee. Now regarding the Estimates Committee, it has 30 members and all these 30 members are from Lok Sabha only, and Rajya Sabha does not have any representation in this committee. And these members are elected by the Lok Sabha every year from amongst its own members according to the principles of proportional representation by the means of a single transferable vote. So an important point that should be noted about this committee is that all the parties get due representation in it. And this is because of the proportional representation procedure for the election of members to this committee. And hence the first statement that is given here is incorrect, that it consists of members from the ruling party only. However, the only clause is that it consists of members from the Lok Sabha only. And because the members to this committee are elected based on the proportional representation system, all the parties get due representation in this committee. Now regarding the second statement, the function of this committee is to examine the estimates which are included in the budget. And in this line, it suggests economies in the public expenditure. And that is why it is also described as a continuous economy committee. Further, regarding the second statement, the demands for the grants are the expenditures which are presented by the government in the form of demand to the House or the Lok Sabha. And this demand becomes a grant only after it has been duly voted by the Parliament. And regarding this demands for grants, there is no condition that it has to be first examined by the Estimates Committee. And thus the demands for grants may be voted upon despite the fact that the Estimates Committee has made no report. So in short, it examines the budget estimates only after they have been voted by the Parliament and not before that. And hence this second statement becomes incorrect here. And thus the correct answer here is D, that is neither the statement 1 nor the statement 2 are correct. Now one important point that should be noted about these two questions is that normally we have a tendency to consider all those statements where words like only or all find a mention. And we have a tendency to strike these statements as incorrect. However, as you can see in the question number 8, this statement where the word only has been used is correct. However, in this question where the word only has been used, the statements are incorrect. So thus while solving, you should not go with any preconceived notion regarding such words that find mention in the statements in the preliminary examination questions. After this, let us take up the last question for today's discussion. Now the last question is related to the status of the Indian Parliament and is also related to the parliamentary privileges. Now in this line, the question reads that consider the following statements about the Indian Parliament. First is that the Indian Parliament is a sovereign body. And the second statement is that the parliamentary privileges have been exhaustively codified by the Parliament under a statute. Now, a sovereign body means that it is the supreme power within the state. And further, in its exercise of power, the Parliament should not have legal restrictions on its authority and jurisdiction. So, in this regard, the doctrine of sovereignty of Parliament is normally associated with the British Parliament. And this is because the British Parliament is supreme within the state of Britain. And this supreme power in Great Britain lies with the Parliament because there are no legal restrictions on its authority and jurisdiction. And that is why the sovereignty of Parliament is a cardinal feature of the British constitutional system. However, the Indian Parliament, on the other hand, is not regarded as a sovereign body. And this is because there are legal restrictions on its authority and jurisdiction. And these limits on the sovereignty of Indian parliaments are because of the various features of the Indian constitution. And this is because India has a written constitution, which is not the case in Britain. Further, the authority and the jurisdiction of the Indian Parliament is restricted by the judicial review which has been provided to the Supreme Court. And also it is restricted because of the fundamental rights which have been provided in the Indian constitution itself. And thus this first statement is incorrect that Indian Parliament is a sovereign body. Further, in the second statement, the parliamentary privileges are special rights, immunities and exemptions which are enjoyed by the two houses of the Parliament, their committees and their members. And these privileges are considered to be necessary in order to secure the independence and effectiveness of the members of the Parliament and the members of the committees, etc. Now, regarding the sources of the privileges, the Indian Constitution under the Article 105 has provided for two privileges, and that is the freedom of speech in the Parliament and the right of publication of the proceedings of the House. And initially it was provided that the privileges of the Indian Parliament will be same as those of the British House of Commons. However, the 44th Constitutional Amendment Act removed the reference to the British House of Commons which was provided in the original Constitution. And it provided that the privileges of each house of the Parliament are to be those which they had on the date of its commencement until defined by the Parliament. And accordingly, the Parliament till now has not made any special law to exhaustively codify all the privileges. However, these privileges of the Parliament are based on 5 important sources, and these are the constitutional provisions, various laws which are made by the Parliament, rules of procedure of both the houses, parliamentary conventions and the judicial interpretations. And hence this second statement is also incorrect here. And the correct answer that comes out is D, that is neither statement 1 nor the statement 2 are correct here. With this we conclude today's discussion, and for the third video of Indian polity, you should start revising these topics, that is the judiciary, Supreme Court, High Court, etc. Again, this next topic will be governors, state legislatures and state executive. And then there are 2 other important topics like the Panchayati Raj institutions and the schedules of Indian Constitution. Further, keep practicing more questions from the topics that we have discussed today from a standard test series. And stay tuned for more videos.